have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Thank you for watching Truth and Justice with Vivian King. I am your host, Vivian King, and I have in the studio with me Miss Cheryl Irvin, who is a famed criminal defense lawyer in Houston, one of my favorite criminal defense lawyers. She's one of the people that I go to when I need a second opinion. She has a new twist on a possession of cocaine case. She recently had a trial in Harris County, a felony trial that she got a not guilty in, and it's a different kind of case. I want to educate you about what the police can and cannot do through going through the process of this drug trial. Let me tell you what the probable cause was. It's a different one. Basically, the officers in the Northeast Differential Response Team, October 12th, 2012, at about 10:45 in the morning, went to a residence on Bolden Street and conducted a follow-up investigation of a nuisance violation. Check this out, nuisance violation. Now, the nuisance was, they'd been there about 8 days before, and they noticed that there were some nuisances on the premises at the house. Dead tree limbs. Looks like the exterior walls were in bad repair. Listen to this. Failure to store automated collection equipment away from public view. What is that? Trash can. Failure to put the trash can away from public view. Failure to maintain plumbing in good repair. What does that mean? So a pipe is leaking outside. It's a pipe leaking outside in front of my house right now. But anyway, so these are the public nuisance violations that they're investigating. So they knock on the door. And these officers are trained in city code enforcement. And they knock on the door, and these two gentlemen answer the door. They go inside. The officer shows them the violations from the exterior of the house. Remember the leak, the trash can, the limbs in front of the house, exterior walls that don't look good. They show these violations to them. They make them come outside, and they just want to go inside so that they can figure out where this outside leak is coming from. So they ask the two guys who they show outside, they bring outside and show the violations. They ask, the officers ask, can they go inside? Because now they want to figure out where the leak is coming from. Man, I've never had a police officer try to be a plumber, but they want to look at the kitchen sink. So they go in the house to look in the kitchen sink, and they notice that there's cocaine in the kitchen. They notice that there's cocaine or scales in the kitchen that could possibly be used for cocaine. They notice that there are baggies or bags and a plastic Pyrex cup. They also notice that it smells like marijuana coming from one of the bedrooms. Now, they've never said they've searched for security or safety. They haven't gone through the house. They just think they smell marijuana coming from the bedroom. They're already inside the house seeing this cocaine. So they call the DA's office and get a search warrant to search the bedroom and the rest of the house, where they have probable cause now because they smell marijuana coming from the bedroom, even though there's nobody in the bedroom, because the two occupants are with them. So they maintain these guys under arrest, basically. They detain them, take them outside, get a search warrant, go pick up the search warrant, go back to the house, search the house, and in the bedroom, they smell the marijuana. They find approximately 52 grams of marijuana. In the bedroom, they find a lease agreement made out to one of the guys, we'll just call him Ricky. And so since there's a lease in the bedroom and Ricky is one of the two guys, it's Robert and Ricky, then they take Ricky to jail for all of the drugs in the house. And it seems like a very impossible case. So that's the police officer's probable cause. And I will now turn this over to Ms. Irvin so she can tell you how she dissected this case, how she investigated it. She had her investigator, Carolyn Porter, who's also my investigator, one of my two investigators, who was not able to be with us tonight. But she's going to tell us what type of investigation they did and how they actually ultimately pulled this off. So, Ms. Irvin, without any further ado, tell us how this miracle unfolded.
Well, let me just say from the start, we were not interested in going to trial with these facts. We were somewhat forced to go to trial. We didn't have any choice. And that was because my client was on probation, deferred adjudication out of another county for
a felony or misdemeanor?
Burglary of a habitation, 2 to 20. And they told him that if he takes anything in the case here in Harris County, they were going to revoke his probation. Done deal. No question about it. So we spent quite a few months waiting for them to tell us exactly what position they would take on the case in Harris County. So if they eventually told us anything that happened here besides a dismissal or acquittal, probation would be revoked up there. So once that was somewhat sealed, we kind of knew that we were going to go to trial, period. We were forced to go to trial. My client also had a conviction for burglary of a building, for which he received 7 months state jail. So now I'm confronted with, he has a felony conviction and he's on deferred adjudication for burglary of a habitation. Not good facts for a defendant who is generally your primary witness in a situation where you have the basic testimony coming from police officers.
And let me stop you there. One of the things you have to keep in mind, I know some people are saying, oh, these slick defense lawyers have just gotten someone off. But remember those facts. These officers, doesn't it appear, have gone into this house under false pretenses, playing like all of these outside things that we see every day, limbs outside, trash can. You can see the trash can at the city trash can. There's a leak outside, bad walls. I mean, these are nuisance violations that the officers are saying they need to go into the house to try to figure out where the leak is coming from out of the kitchen sink. I mean, have you ever had an officer do that? So think about the unfairness. And remember, our Constitution and our laws are supposed to be fair, and they're supposed to have safeguards. Remember the Fourth Amendment. You can only go into one's home with a warrant. You have to have it before you go in. You don't go create the reason for the warrant. That's sneaky, and that's not fair. So remember, a defense lawyer's job is to make sure that your constitutional rights are protected, that the police officers are playing fair, and that if they go into your home, they already have the probable cause to believe that there's a crime because someone's already seen it and sworn in an affidavit that they've seen the crime inside that house, so that a neutral magistrate or a judge can sign a warrant to go in. The officers are not supposed to sneak their way in on false pretenses, say they smelled marijuana, which makes no sense to be in a house in a kitchen with the two occupants, and say you're still smelling marijuana. Remember, this smell of marijuana is everywhere. Traffic stops, smell of marijuana, but there's never any marijuana that's taken or burning cigarettes of marijuana. Inside this house, are we to believe that there's really marijuana contained in one bedroom and like somebody's smoking it when nobody's there? Because if it's in the house, it's just in the house. So let's think about the facts and think about the fact that her job is to protect his constitutional rights. So how did you protect his constitutional rights?
Well, the first thing was to dissect the offense report. And the biggest problem we had from the very beginning is that in the offense report, the officer said that he had been at this particular residence 8 days earlier, saw my client, talked to my client, and my client said, according to what he said, that he lived there and he would take care of the repairs. Okay. So that's the first thing. So now, here you have an officer, same officer, 8 days later, coming back to the residence. The person he sees is the same person he saw 8 days ago. And so, as far as the officer is concerned, he's saying that my client lives there. And it's not illogical for him to think that because he sees him there on 2 occasions. And they walked around the property the first time saying, you need to fix this, you need to fix that. And here he is, he's coming back again to see whether or not those items have been repaired. And obviously he sees the same individual, which is my client. So their position from the very beginning was that my client lived there.
Okay.
And so we had a different position. My client did not live there. So we began first by hiring an investigator. Once again, we hired the famous Carolyn Porter.
Famous Carolyn.
The famous Carolyn Porter. Tremendously dedicated, unbelievably
Skilled.
compassionate about what she does, skill, and will search and find an ant if you ask her to.
Yep.
That's Carolyn Porter. So I asked Carolyn Porter to go take pictures of the place, of the residence, because one of the things the officer said when in the report was that when he knocked on the door, this is the second time, that he could see my client standing in the kitchen. And if you think about it, if he's standing in the kitchen, then he's in the kitchen where all the paraphernalia and all the activities, which was clear to anybody's mind, it looked like a dope-making kitchen. You had the Pyrex, you had the baking soda, you had the baggies, you had the scales, you had the microwave, you had dust everywhere, and you had some grams of crack. So it clearly looked like that's what was taking place in the residence. So, but even though the officer said that in the report, and that's what he testified to, we believed that we had a more truthful story, and that's what my investigation began with Mrs. Porter. First of all, it did not become an element in the case, but we knew the officer was not telling the truth when he said that you could see my client standing in the kitchen when he knocked on the door, because from where the kitchen and the door is, when you open up the door, you can't see who's in the kitchen. No house is built like that.
Right.
That did not become an important element in the case. It may have been, but we were prepared to address where the officer said he saw my client. So, but what I had Miss Porter do, because the issue became who lived there.
Right.
They said my client lived there.
Right.
And their reason for believing he lived there was, one, he was there on 2 occasions, and 2, when they did a complete search of the place, they found a lease in my client's name.
Right.
So they believed that he was in possession of the place. He had a link to the place, being the lease that was in his name. Okay. So Robert, another person who was arrested and then released, who was also present at the time, they did not charge that person, and the reason being they don't believe he had enough links to the place. Well, they couldn't find anything in the place that was connected to his name. They didn't do a complete investigation, in my opinion. They didn't try to see whether or not the water was in his name, light bills, any of those things which indicate ownership or possession. They didn't do any of that. That was some of the things I brought up during the course of the trial. But what Mrs. Porter did for me, I asked her to go out there and talk to the people in the neighborhood, find me a witness that can testify to who lived in that house and who didn't live in that house. So that was one of the things that Mrs. Porter was able to find out for me. And she did find me a witness, a reluctant witness, who eventually was able to testify that my client was not the person who lived at the house, but the person who did live at the house, the one who they released, was the person who did live there.
Robert. Wow. And was the reluctant witness a neighbor that observed that house on a
She was a neighbor.
basis?
She was 2 blocks down and could see the house from her residence.
Interesting. And when you went to take pictures of the residence, did it look like it was in any more disrepair than other houses in that neighborhood?
It probably was a little bit more in disrepair.
But it was livable. It was
but
habitable.
It was habitable. It didn't appear like it wasn't as well kept as the other houses were. And it could very well be that somebody had called and complained about the house was in disrepair. It would be logical to me that somebody did have that complaint.
Now, did y'all ever determine who actually lived there? I mean, who owned the house? I'm sorry, who owned the house?
We did determine who owned the house, but that person had leased the house to somebody who had leased it to somebody, so we weren't able to follow that lead. Okay. That was pretty murky there. We weren't able to find out who actually leased the house.
Gotcha.
And nobody was willing to come forward and say they were the persons who leased the house, and I certainly did not expect anybody to do that.
Okay. So what was next? So you got pictures of the house to see that you couldn't see the kitchen from the front door. Mm-hmm. We know we got an independent witness who has no dog in the hunt that says that Robert lives there, not Ricky, the person who was arrested. And what was your next step?
The next step was I needed to develop my client's story as to why he was there. Why he was there that morning when the police officers knock on the door again and see him in the residence. Need to have understanding as where did he live, and why was he there on that particular night in question or that morning. And so I had several meetings with him, prepared him to testify, found him to be a handsome fellow, articulate. He had attended 2 years at Prairie View. Something that the jurors were impressed about was that when he was at Prairie View, his girlfriend got pregnant, and she could not work, which meant that she was bedridden. So he left school in his 3rd year at Prairie View and moved in with her. Her mother had moved to Iraq to work, so he came in and took care of her and then they lived together until their child was born. And that's the same house that we believe he lived in on the date that he was arrested in this house on Bolden. So the question was, why was he there that morning? So we had to develop an understanding of what brought him there. And so I talked to his girlfriend, I talked to his family, and his father testified as to where he lived. And I talked to his brother-in-law, who testified as to where he lived. And then I talked to his girlfriend about why in the world, why was he there on that morning? And she wasn't necessarily a great witness, but you could see probably what happened. And this is how we develop our story. Somewhat around about 2:30 in the morning time, he's awakened by her hitting him in the head. And what brought about that? Because she looked at his phone and saw some texts with some pictures of women. And
pictures of women.
And so
probably vulgar pictures, as these young people do.
Anyway, she wasn't happy about it. And so she told him to get up and get out. And of course, it's her mother's place, so
he has to get up.
He has to get up and get out. And so the only thing he takes with him are tennis shoes, T-shirt, and some shorts. And he just gets out and goes walking. They only have one car, and she needed the car to go to work in the morning time, so he didn't take that. Would not be.
Now, is the baby born already?
Oh, the baby's born, and she's a beautiful little girl, and she's a daddy's girl too.
Okay.
And we had pictures too that showed him interacting with his baby girl, and it was clear that this kid loves his daughter, and so he testified about how he got up. And he was walking down the street 2:30 in the morning time, didn't know where he was going. And he testified, he said he made up his mind that morning that he wasn't going back to stay with her again because he had really had enough of it, of her being jealous. So he ended up knocking on this Bolden address where this Robert guy lived. And he came in and laid on stayed up for a minute and laid on the couch and went to sleep. And finally went to sleep because he's not sleeping in his bed, sleeping on the couch. And so he testifies that when the police knock on the door, he's simply laying on the couch and he wakes up because...
and it is, when the cops knock on the door, it is, according to the police report, 10:45 in the morning.
Right. So, and he works night shift at Dish Network, so that would be about the time he's getting off.
Okay.
But he was off that day. And so when they knock on the door, he kind of jumps up a little bit disoriented because... he didn't sleep well. And so when the police knock on the door, they go outside, want to show, look at the place, and then they want to come inside and look at the place. And one of the things that the officer said, they were trying to sneak in somewhat. He said that during that time, my client was, okay, well, whatever you want to do, I don't mind, just, but, if you want to look at this, help yourself. But Mr. Jenkins was very quiet, and the officer happened to slip that out. I said, well, what Mr. Jenkins doing at that time? Well, he was kind of quiet.
Let's call him Robert.
We'll call him Robert. Yeah, we'll call him Robert.
So Robert was very quiet.
Robert was very quiet. So, and so I asked the officer.
Accidentally slipped that out, that Robert was quiet.
Yeah, he's kind of quiet.
And Robert just happens to be the one that the independent witness says actually lives there.
So he kind of slipped that out by mistake. Mm-hmm. That was a mistake.
That was a mistake.
And so after he slipped that out, I pounced on him on cross-examination about it. But that indicated to me that he knew something was going on, whereas my client was seen to be whatever the officer asked, he did.
Right. Whatever you want to do, you want to look, you want to look. I don't care.
I don't care. And then another thing that was important was that somebody had gone to McDonald's that morning, but it hadn't been my client. Okay. And so you could see where someone was eating McDonald's. It was Robert. And so my client testified, no, I hadn't left the place. I had not awakened. I didn't know Mr. Robert had gone anywhere. When he came back, he didn't bring me anything. He didn't wake me up and ask me for anything. So it kind of indicated that when my client says that he had gotten there late at nighttime, did not sleep well, and only awakened to the knocking at the door, it kind of indicated maybe that makes a little sense, that he had just gotten there and did not know what was going on in the place. So my client testified, did a very good job. During the course of the testimony, obviously the state was able to bring out the fact that he had a conviction for burglary of a building and that he was on deferred adjudication for a burglary of a habitation. Mm-hmm. So, in order to trying to destroy his credibility. But one of the things that was important to me in preparation for this case was to be prepared, to have my client be prepared. And this case was tried the day after 4th of July. And I was scheduled to go to Atlanta for a family reunion. But even though my family insisted that I come, I told them I could not. I needed to stay in town. I can never tell what can go wrong with a case. And so I needed to be in my office that Saturday. I needed to be in my office that Thursday. I let my client have Friday off to have vacation with his family on the 4th of July, but I did not. It was my intention that my mind be set to try this case because we needed to win it and we needed to do everything we needed to do. We needed to be in position to do everything we needed to do to win the case, and that meant being focused. So,
can you hold your thought for
sure.
a moment? Caller, I see that someone's waiting. Please turn your volume down and ask your question. Thank you for calling Truth and Justice.
Oh, hello, Ms. King, Ms. Irvin.
Hello, sir.
And I want to say hello to Equator and Ms. Porter. I'm sure they're listening. You got about 800 members on your Facebook fan page now. You know that, huh?
No, I didn't know that, Tracy, but thank you for the fan page and thank you for keeping up with me. I appreciate it.
Okay. I like when, you have Ms. Irvin on and, because I learned so much. I've been, from everybody.
Oh, yeah. Ms. Irvin's been a lawyer a long time.
Yeah, I think I'm going to have both y'all represent me. Y'all been tagged if I ever get in trouble.
But you're not going to get in trouble anymore, Tracy.
We're going to use Ms. Porter for the investigators.
That's right.
Okay, look here. Let me get what I call about. I guess one benefit, with the HOA, the Homeowners Association, they offer, some kind of protection from that, I guess, because, if you were doing anything that was going to be a public nuisance, they'll let you know. Or, you get a letter from them or your insurance company.
If you live in a newer neighborhood that has a homeowners association, so this is an old neighborhood, just like I live in 3rd Ward, there's no homeowners association. So, yeah, the newer subdivisions do have them that are still active, but they can expire, and then from there, the city would basically be policing. But they usually they usually don't police this strong, though.
What about civic clubs and
civic clubs can do it, but they don't have power. Homeowners Association have legal power where they can actually take your residence from you. Civic clubs are just that. They're clubs, and they don't have the legal power to enforce.
Oh, okay. I guess the reason why I was saying the Homeowners Association had advantage because they'll let you know before the police get to you.
Yeah, they do. They do.
Or your insurance company, if you got insurance.
That's true.
You'll get a letter.
That's true. This is quite unusual. That's why I thought it would be interesting for us to go through this case study.
Okay, but look, I'm not gonna hold up the line. I want hear Ms. Irvin, finish dissecting, because it's very interesting.
Thank you, Tracy.
Okay, bye.
Okay.
So, so preparation. You want to know your case law, and you want to know what the indictment says, so you know what the state has to prove. Then, of course, you want to know the case law, so you know the elements of what they have to prove. And so you've got to prepare your voir dire for the jury, anticipating as to what they will hear when the trial occurs. So those are the things that I was focusing on in preparation for this case. But something that I thought that turned out to be more important to me this time around than before. One of the things I asked the jury panel is that what they saw the role of the prosecution, what did they see the role of the judge, and what did they see the role of the defense attorney? And it so happens that we have the Declaration of Independence that's we're celebrating, and so those rights that are embodied in the Declaration of Independence and in the Constitution, people are more sensitive about them that time of the year than other times of the year. So as I focus on what I thought what I was asking them what they thought these roles should be. Then I asked them, what did you think the role of the defense attorney should be? And I asked them, do you want me to be a mealy mouse defense attorney, or do you want me to advocate for my client? I said, because that's what my job is, to advocate, to make sure that all his rights are protected. They agreed with me that they wanted me to be an advocate, to want to speak up, to be a force for my client. And during the course of the trial, this is the reason why I want to mention this. During the course of the trial, I was cross-examining one of the officers, and I was boxing him in left and right. I mean, when I tell you, I was wearing him out. The judge all of a sudden yelled, "Stop!"
The judge yelled at you?
Oh, he yelled at me. "Stop!"
What judge is that?
Judge Guerrero, but he didn't mean any harm. But he was just
Don't defend him. He yelled at you.
He said.
But why would a judge stop you? The Constitution says you're supposed to cross, and it doesn't say the judge is supposed to stop you from crossing.
I don't know what he was thinking, but so anyway, so I was, like I said, he said, "Stop talking to that officer like that. Stop asking him yes questions."
Sponte.
Oh, just off the chart, just out of the. It was just unheard of. I never seen that happen before, but I took it in stride,
right.
And then I continued to do what I did, and so, but then during the closing argument, when I reminded them what they expected of me as a defense attorney, and I had no compunction, no remorse, and no fear, and I said specifically, when I was cross-examining that officer, when I was asking him those yes and no questions, I said no disrespect for the judge, but that's exactly what I'm supposed to do.
Right.
And they appreciated that. Because we had a chance to talk to them later on. And so, so the thing is, you have to know your role and never let anybody take it from you. And if your role is just to defend and to advocate for your client, that's what you do.
And Judge Guerrero does have problems with that. You can. A lot of my fans have Googled Judge Guerrero, Vivian King. We were written up in the Houston Press about a case I had to fight him tooth and nail about because he seemed to be on the prosecution side. It's a pretty famous case. It was in the May 2009 issue of the Houston Press. So he is one that will jump in for the prosecution, although he's never been a prosecutor, I don't think, so it was just so weird to me.
Yeah, it is kind of weird.
It's kind of weird. But anyway, and he is a nice guy, so I'm not beating up on him, but he will help the prosecution when they don't need any help. I mean, because the prosecution does not control what the officers do. I mean, they weren't there. They can't tell them to change what happened out there. All they can do is try to present the officer's story in the best light, but the officers can't lie. They're not supposed to be lying on citizens, and they're supposed to arrest you properly, and they're supposed to do proper investigations. There should have been a drug investigation, not the pretenses of a nuisance, and then it turns into a drug case. That's not what you're supposed to be doing. You need to be sending somebody in there to buy drugs. You need to be conducting a real drug investigation so you know who the drug dealer is, not someone who just happened to be there. Tell me, though, Ms. Irvin, how did you deal with the fact that your client was also there 8 days before? How did y'all deal with that?
So, my client, the reason why the lease was there was that my client had leased a place for his brother-in-law who had bad credit. My client had good credit. And so the brother-in-law was moved out of that place and moved and put his stuff into this house. Robert let him store it there while he decided whether or not he was going to get another place or stay with his girlfriend. And so that's how we dealt with the lease being there.
So the lease that was in Ricky's name, your client's name, was for that property?
No, it was not.
Oh,
it was for another piece of property.
Okay, well, but it was there because Ricky had left some property there.
Well, I didn't say it very clearly. Let me do it again. The reason why he was there, he had helped his brother-in-law who moved out another place store his furniture, 2 bedrooms of furniture in that property.
On October 4th, 8 days earlier.
That's correct. And so
when the officer came 8 days earlier, Ricky was still there. Were the other people there that had moved the property?
No, they had all left, and so he was the last one there putting everything in and locking the place up.
Okay. We have another call. Caller, thank you for calling Truth and Justice with Vivian King. What's your question?
Hi, good evening. I would like to, my question was, is it lawful, I know it's probably not, for the judge to interact like that and show sides, like he's with the prosecutor and he's trying to get a conviction, or he don't like the particular lawyer, the defense lawyer? Could the judge actually, is it lawful for them to sway one way or another.
No, it is not lawful.
And it's not judicious and it's not ethical.
It's
either.
not. It's unethical. It's against the code of judicial conduct. So it's not like he can go to jail for it, but a judicial complaint can be made for that. But generally, because jurors in Harris County try to be so fair, when judges get involved when they shouldn't, it usually hurts the prosecution. It hurts the side that they're on. Unless it's just some kind of horrendous, awful crime where it's a bunch of dead bodies and the jury hates the defense anyway. But if it's just a case that can go 50-50 and the judge seems to be trying to take sides with the prosecution, which judges do a lot in Harris County, jurors don't like that. They want it to be a fair fight, and they want the judge to be the referee, like I've taught you the judge is. The judge is the referee of the law, is not supposed to take sides. Everybody's supposed to fight their own battles and let the judge just rule on what's admissible and what's not admissible. But to stay out of it. In fact, a judge cannot comment on the weight of the evidence. A judge cannot start asking questions in state court, and this is state court. In federal court, the rules are different. Judges can get involved, but you can't get involved in state court. So the judge, you'll never see in state court a judge turn around and say, I'm not quite sure what that answer was. Say that again. I mean, they're not allowed to do that because it looks like they're helping one side or another. So it's against the judicial rules of conduct. Any other questions, sir? Okay, guess he's gone.
That's one of the reasons why in this particular voir dire, I'm not sure why I did it, but I'm always trying to perfect my voir dire, which I think is the most important part of the trial.
The jury selection process. When there's 65 jurors or 64 jurors brought over, and we have to narrow it down to 12. So that's what she's talking about. That's the voir dire part.
I'm always trying to perfect it, to make it better, to make it more concise, to make it more reflective of what I think that I'm going to expect in the trial. And in this particular trial, I talked about the roles that each party would play. And it turns out to be very important because it seems like the judge, in a couple of instances, he was showing a little favoritism to the state. And so, but I didn't have any problems with doing the closing argument, pointing out that he was out of line. And with all due respect to him, about telling me not to ask yes and no questions
right.
to the witness. That is the greatest tool that a defense attorney has is in cross-examination is your yes and no questions to the witness. So the other thing I thought that was helpful was the client had I thought a very believable story about why he was there, and generally sometimes we share with the prosecution what we think our story will be. Maybe they'll dismiss the case and maybe they won't. I didn't think they would dismiss the case. I thought they would take my information and use it against me. So I told them nothing about my defense. And
let me stop you there, Cheryl. One of the things that a lot of the defense lawyers do, I would say at least 50%, maybe 60% of them do, is they do share the defense with the prosecution. And if you're a good trial lawyer like Cheryl and I are, this is the problem with that. If you tell the prosecution what your defense is, then they go back and tell the police. And then the police changes the story. They'll keep with the basic police report, but then they'll ad-lib all of the rest of it to answer what your defense is. And remember, in trials, the state and the police go first. So the state presents all of their witnesses first, and you're just cross-examining them. So if in negotiations, this case was 2 years old, almost a year and a half when they tried it, Cheryl's been going to court every month on this, and if she said, well, my guy was doing this, then when it comes time to trial, the prosecution is going to call the police and say, look, we got to go, this case has been set for trial. We were told that he was there because he had a fight with his girlfriend. We were told that he'd been there 8 days before because he had moved his cousin's property there. He doesn't live there. He'd been living with his girlfriend. So go find us some more information to show that he lived there and that you released the right person, because you released Robert, and how did y'all pick to release Robert and not Ricky? So how are we going to prove this? Because you don't have that in the police report, and we're going to have to answer to that. So then the police have an opportunity to ride by the house some more, to do later investigations, to try to shore up the information that they got before, and that's not what they should be doing. They should be able to convince a jury beyond a reasonable doubt as to what they found October 2012 at that house. They shouldn't be checking out our story afterwards, unless they're doing it to release him or to try to prove that he's innocent, but not to try to find additional information and play like they had it back in October when they didn't put it in the police report. That's why if you're ever on a jury or you watch TV and it's a real trial, you'll hear the defense lawyer say, but it's not in the police report. Because those are sometimes facts that officers add because the prosecution has told them what the defense is. So since they go first, they already addressed those issues first, so it looks like you're lying when you get up there to tell your story. So you have to know whether to trust the prosecutor you're dealing with. Now, Cheryl and I know that there are over 250 prosecutors in Harris County, and there are some you can trust with the story. I mean, you can tell them what the defense is because they really are trying to do the right thing and be objective about the facts to see if what the officer said makes sense. It might even have enough integrity to tell the officer, this is not the way you do a drug case. We're not going to send anybody to prison when you're playing like this is a nuisance and you've tricked your way into going into the house because some snitches told you that they're selling dope up in there. And you've gone there on the wrong date because Robert is the one that's probably the one selling dope. So, I mean, you know, sometimes, prosecutors don't have that real honest talk with an officer. They'll just try to figure out a way to make their story make more sense. And that's the danger if you have an inexperienced lawyer or if you hire a lawyer who does not go to trial, because they're going to always share your information because they're plea lawyers. And to plead, you got to try to give as much information as you can. But trial lawyers don't do that unless we trust the prosecutor.
Another thing that I think is important is that now I don't believe these officers were there to investigate
a nuisance.
No, I don't believe they were. I believe they were there to investigate a nuisance. I really do.
Oh, you do? Okay.
I don't think they were there to do investigation of a drug case. But what the DA's office was doing when they didn't see their case going as well as they thought it was, they started saying things like that the reason why they were over there was because they had gotten a call about a lot of traffic being over there, indicating somebody come in there to buy drugs.
Now, the prosecution threw that in?
They threw that in, but that's not in the report.
Right.
So it's kind of, so she's had different
So where did
theories.
That come from? Did that come in the opening statement, or where did you hear that?
It came in one of her witnesses. When the first officer didn't do very well.
So then all of a sudden they throw some more facts in.
Right. So the second officer, after she has a little 5-minute break, then he starts saying stuff that wasn't in the report.
Like he heard that there was a lot of traffic over there.
Right.
But that's not your job.
But that's not what he heard because that's not why he was out there.
Right.
So it didn't make it. So you knew that wasn't truthful. They just was trying to,
And see, that's what prosecutors should not do.
They shouldn't
prosecutors
do that.
should not be telling the officer to lie. Because, I mean, that's what the Constitution is about. And remember, I remind you that a prosecutor's oath is not to convict, but to see that justice is done. Is that justice? And as a juror, your job as a citizen is to keep the process fair. Are they supposed to go and tell the officers how to lie to keep this case alive? Or are they supposed to dismiss the case when they realize there's something wrong with it?
So I felt like when that little break, when the second officer came on, that there were some things that the first officer screwed up on, or just
didn't screw up on. He just told the truth.
Yeah, just
and the truth just wasn't strong.
Wasn't what they wanted to hear. Then tried to solve the problem with the second officer, and so the other theory was that when they're trying to explain why did my client take them back in the kitchen when there was all types of drugs back there. The explanation that the state had was that, well, these individuals didn't think these officers were smart enough to know that when they would see the paraphernalia, the baking soda, the little bags, the scales, that they would not know that was drugs.
Really?
So that was kind of like a particularly peculiar explanation for some trained officers not to know what that was.
Wow.
So so that didn't make very much sense.
No.
So.
Wow.
Yeah. Wow. So
we talked about the lease. How did you deal with the bedroom issue, about the marijuana in the bedroom? How did you deal with that in trial?
Well, it never really became a big issue, but what I did deal with was the fact that there was clothing in the bedroom, and that the two individuals, Ricky and Robert, were different size. One was tall, one was short. The short person was a little heavier. So I asked them that they go and find out, try to make a determination as to whose clothes belong to. Because, you
You could clearly tell the
clearly
difference
tell
that
the
one
difference
person
in-
would wear one
right.
size and one person would wear another
Right,
size.
you could figure that out, but they made no, they did nothing with that. I asked them to try to determine whether or not my client had a key to the residence. We had a pretty contentious argument on that. We were never able to determine whatever happened to the key. Who had the key to the house? We couldn't figure that out because they didn't know what they were doing with reference to the key.
Well, what about your client? Was he arrested with keys?
You know, he didn't have any keys. That's what our argument was. He had no keys at all. He just
Right.
walked out the house.
Right.
And so they're saying that they gave him the house key. And
Wait a minute. Hold on. Who gave who the house key?
that's what the police officer was saying, that the house key to the key to the house, they gave it to my client, gave it to him, put it in his property. But we were never able to find it.
So in your client's property at the sheriff's department, there were no keys.
We couldn't find a key.
But the officer said there was.
Right. So Ms. Porter was able to get the list of things that was supposed to be given from my client when he released from jail. It did say one key, but it didn't tell us very much. And my client was adamant that he went to jail with a T-shirt, tennis shoes, and some shorts. And there was a little bit of conversation about how did my client arrive, because there was a car outside. It was Robert's car. And so they were trying to say that was his car. But again, when my client was released from custody, he didn't have anything. So that would indicate
He didn't have any car keys.
He didn't have any car keys either. Now, another person I called as a witness was the Mr. Carter from pretrial. When people are interviewed at pretrial when you're arrested, you're in a non-confrontational environment. People tend to give correct information. You know, it's not police officer arresting you, just somebody asking you where you live, where you go to, did you finish college, who's your close relatives. And so at that point in time, my client gave his address, not the Bolton address, as to where he lived. So Mr. Carter came in and testified as to that information being listed in the first interview of my client when he was arrested.
So Ricky never gave that address?
Never gave Bolton address as a place where he lived.
Which address did he give? I'm curious. Did he give his girlfriend's address or his
He gave his
parents'?
girlfriend's address, where he had been living for a couple of years.
Okay.
He and his daughter and the girlfriend.
So that was good.
That was good.
Now, what about the neighbor? How did she react? Was the neighbor, the independent neighbor, did you have that person testify?
I did, and she was very reluctant to testify.
Was she an older woman, younger
She
woman?
was, I think she was in her mid-50s, but she was very reluctant because she was concerned that people in the neighborhood would consider her to be a snitch or something like that.
And what did she testify to?
Well, once again, Mrs. Porter, I asked her to get me a picture of Robert, and so I had her testify so she could recognize that person. And she said, "That's Robert." I said, "Can you tell me where he lives?" And she said, 11 blah 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 Bolden.
Right.
And
Which is the
which is the
resident of the arrest.
address of
And
the
Robert
arrest.
is the person that the police determined didn't live there
that's
and
right.
it wasn't his drugs
Right.
and let him go.
And then I asked her.
And so,
I asked her, do the person you see sitting next to me in trial, does he live at? Do you know whether or not he lives at that address? Yes. Does he live at that address? No, he does not.
and so how did she know that he didn't live there?
Well, because she knew where he did live. So I didn't ask her.
But she did know Ricky.
She did know him.
Okay.
She knew him. So I didn't ask her how she knew him. I just simply asked her if she knows whether or not he lives
Right.
there.
I'm just trying to find out if the prosecution asked any more, or they were afraid to ask any more because they didn't want to know what was going to answer.
No, they didn't pursue that.
Right. And if they would have, she would have said where Ricky actually lived,
That's
which
right.
is not that house.
Right. And she would have said how she knew where he lived.
And even though, let's say that the police said he didn't live there and you established that he didn't live there, he still could have been in care, custody, and control of those drugs. So how did you prove or disprove that he was in care, custody, and control of those drugs? Because you can have drugs at somebody else's house.
That's absolutely correct, and that's really when you get down to the core of the question, because he could still be there, and he could still be living there. I mean, not be living there, but be there for the purposes of being a joint venture to sell drugs. He could be there. So the way we handled that issue was his testimony. His testimony told exactly why he was there, how he got there. And essentially that he had not really been around in the residence, that he just slept on the couch. He was awakened by the knock of the door, which was hard, by the police officers. He jumps up. When he jumps up, the police officers see him. He see them, and then he just, whatever they ask him to do, he does it. When they say, "Can we show you something?" he goes outside and follows them. And even though he's telling them, I don't live here, but I'll do what I'll go where you ask me to go. And here's something that turned out to be really important too, that we learned during the course of the case, is that you could get an occupancy ticket, meaning that if you own this property and it doesn't have proper plumbing and the police officers can actually write you a ticket and make you go to court, even though you don't live there. That's the code, it's city code. I don't think it's constitutional. Probably nobody's really challenged it. But if you're there, they can hold you liable. So what the officers really do when they come out there, they don't really care that you don't live there. They just tell you, look, when I come back again, it needs to be fixed. And you stay there saying, but I don't live here. We don't care that you don't live here. You're an occupant. You're here. You must have these to repair. And so they went from treating him like an occupant to a homeowner. When he kept saying to them, I don't live here, they never wrote that down because it wasn't important to them.
Right.
What was important to them, that he was there. And then when he was there on the second occasion, then they assume and start saying, well, you must live here because you've been here twice.
And what's crazy about that is you would think that they would write the ticket to the person who owns the house according to the Harris County Appraisal District, because that's the person who's ultimately responsible for the house. They're the ones who have to pay the mortgage, pay the taxes. They own the property. So if there's a property deterioration or an expense, it's the person who owns the house that has to pay it. The Harris County Appraisal District doesn't charge taxes to the occupant. They charge taxes to the owner. I mean, the owner is the one that has to pay for it. So that's what makes no sense about that ordinance.
Makes no sense at all. And funny enough, one of the big things we were going to argue, because they wrote the ticket to Robert. They didn't write my client a ticket at all. But it became irrelevant.
So they wrote Robert a ticket, but they released him as not having care, custody, and control of the property, but yet your client doesn't get the ticket, Ricky, but he gets arrested for what's inside the house.
Right.
But he doesn't even answer the door. Robert answers the door.
Right. So it becomes irrelevant about getting the ticket because we learned that they just write anybody a ticket, whether you're the homeowner or not.
But it is relevant in terms of their mindset as to who's supposed to be responsible. Because if you're saying that I don't think Robert has care, custody, and control of the property for the drugs, but yet I think he's supposed to be the person who's supposed to get the repairs done, it does have bearing on their minds.
Well, I just don't think it became an important issue during the course. Once we figured out their job, they just want to write somebody a ticket. Because if you think about it, you know what they're
Yeah, but
doing.
I mean, you have to. But I hear what you're saying. Yeah. But laws, even city ordinances, can't be. They can't be vague. I mean, you know what I mean. They have to have some specificity. You have to be able to have some criteria in which you determine who's supposed to get the ticket. It's got to be a consistent criteria. It can't just be, I'll just write anybody a ticket because I see them here.
I think that's it.
But I know, but that's vague.
But that's what they're doing.
That's unconstitutional because it's vague.
And nobody challenges it.
Right.
I think what they think, if you get the ticket, you own somebody's property, you give it to the homeowner and say,
but the ticket's going to be in your name.
Right. But
they should be writing the ticket in the homeowner's name.
But just think about it. They don't have to fight with the homeowner. They give the fight to you.
Right.
And so they probably have a quota they have to meet, if you think about it. And so now the problem becomes yours instead of the homeowner's.
That's crazy.
It's crazy.
That's great.
I just, I think nobody ever bothers to challenge that, but I know it's completely unconstitutional.
It has to be.
It has to be. But, but who has the time for a $200 ticket to spend $4,000 and $5,000 and $10,000 fighting it? Most people just either don't pay it or pay it.
That's crazy. That's crazy.
Yeah.
Wow. Okay. So that's an interesting twist also in the case.
It's an interesting twist because
so when you talked to the jurors afterwards, what was their mindset about it? Why did they think he was not guilty?
Well,
12 jurors had to decide that Ricky was not guilty of possessing cocaine.
They just didn't think there was sufficient enough evidence.
Even though they knew he was on probation out of another county for burglary. They knew he'd gone to prison before for burglary. Mm-hmm. He did have a job, so that was good.
They actually liked him.
They liked him.
They thought he made a good witness, thought he was smart. They liked the fact that he left school to come home and take care of his girl. They liked that a lot. That he just,
he did the honorable thing.
He did the honorable thing. Took care of it. They liked that a lot.
But what about the fact that he's a burglar?
They didn't like that.
They didn't like that. They didn't like that part.
They didn't like that very much. As a matter of fact, they said, now look here now.
They had to chastise him a little.
Yeah, they told me, say, look now, tell your boy now, he's not all that good, but get his act together.
Right.
So yeah.
And he is on probation, so they knew that he still had to follow some rules and regulations on probation and deserved a second chance. And so that's courage also as an experienced defense lawyer. Most defense lawyers would not put a client with a prior on the stand. Cheryl and I are not of that mindset. We believe that if a client is telling us the truth, get up there and tell the story, whether you have a record or not. Am I right or wrong?
Absolutely.
Tell your story. We think that most jurors can handle it. I mean, you can be guilty of a lot of things. You admit what you're guilty of, but what you're not guilty of, you admit that you're not. And that's our way of doing things. Old school lawyers didn't do that, and some of the new school don't do it. But that's not our style, and it works for us, is to try to tell the truth and just bear it all out. Now, did you get the girlfriend to testify at all?
She did testify.
Did she testify that they'd had a fight?
She testified to the fight, and that she was hitting him. She.
So the jurors probably like that too, that he avoided domestic violence by leaving.
Yeah.
Because she was beating his butt for the nasty picture.
That's right. She started wailing on him in the middle of the night.
Now, when he got out of jail and he was waiting for his trial for a year and a half, did he go back and live with her, or did he live with his parents?
He moved out.
So he did move out.
He did move out.
Okay.
Right. He did move out, live with his brother.
Okay. Yeah. So you had her to corroborate that night.
Correct.
That he walked, he didn't drive.
That's correct.
He shouldn't have had a key to that house. And did Ricky explain his relationship to Robert? Well, I mean, were they friends? Were they partners? I mean, how did he happen to go to his house in the middle of the night?
Ricky happened, that Robert guy happened to be a friend of his brother-in-law.
Okay.
Wasn't a friend of his.
Friend of his brother-in-law, where he had moved the furniture a couple of weeks before.
Right. So he really didn't know Robert. So he just knocked on the door because he didn't have any place to go, and he was walking. He didn't have a cell phone to call anybody to come get him. He just knocked on that door, just said, let me just lay here until I can get my thoughts together, and and call somebody in the morning time to come get me.
Okay. And did y'all call Robert at all?
Oh no. Oh no.
Okay. I was just wondering.
Well, meanwhile, Robert was arrested and placed on probation for possession of controlled substance.
Okay.
So
out of the same house, do you know, or was it?
I'm not sure. I don't. It was not at the same location. I did check.
Okay.
So yeah.
So did that come up in the trial anyway? I mean, it's not relevant. I just didn't know.
No, it did not come up, and I didn't think it would be relevant.
It's not relevant.
Right. I agree.
But I didn't know if somehow it came up.
I thought about trying to find a way to bring it up.
Because that is an interesting fact, because it kind of helps you know that your client is probably telling you the truth.
And it helps us to know that Robert
is a drug dealer. I mean, or has been around drugs, has some association with drugs, and that he could still be arrested for drugs at a later date and get on probation for it. And I would assume this are felony drugs like cocaine, like the same drug.
That's correct. Right. I think that prosecutor would object, and I thought it would have been a problem.
Well, it would have been inappropriate.
It would have been inappropriate.
But the prosecutors knew that Robert had later been arrested. So how did they feel about that?
I don't think they knew.
Oh,
I don't know if they knew. But I don't think they knew. I don't know whether they ran a background check on him, but I did.
Well, you had a year and a half, almost 2 years before the trial. Did you change prosecutors to where enough times to where you had different people you were trying to convince of your client's innocence to try to get them to dismiss it? Or did you have the same prosecutor?
No, I had different prosecutors. I had one prosecutor at the very beginning. He was gung-ho. Let's try this case. Let's try this case. And I kept telling him, I said, it's not what you think. Don't be so hurried to climb this horse. And so then he turned around and said, okay, well, I'll offer you a guy probation. I said, well, we'll think about it.
That's a good deal.
That was for that amount of drugs.
For that amount, how much drugs was it?
It was 50, about 30-some grams of crack, some powder cocaine, some money, 50-some grams of marijuana.
So did he get charged with both the drugs or just one drug?
Just the crack cocaine.
Okay.
So I don't know what the prosecutor, at first he had let's go to trial. He was just ready to go. And I said, just relax, let's just see what happens. And so.
And was your client on bond the whole time?
He was on bond the whole time. So.
Was he able to maintain his job at Dish Network? I
think he lost the job there because he was locked up for a week before he could make bond. Okay. So he lost the job.
Was he able to get another job?
He got another job. I can't think of the name of it. But he also has a job fixing and selling cars. He's a pretty good mechanic. Okay. Can take out an engine, put it back in, all that stuff. Good. He's pretty good at that. So he was able to. He had another job, and he still sells cars. Good. And he works for his grandfather too. So he's quite busy. And he's the guy who picks up He takes his daughter to a daycare and picks her up every day.
Gotcha.
Every day. Now, that was one of the things that was rather touching when I introduced pictures of him at his home with his baby girl.
And at his home is with his girlfriend.
With his girlfriend. This is all before this incident happened. And so I asked him what was the most important thing to him in his life. And he said his daughter, but he couldn't get it out. It was quite emotional.
Aw.
Yeah, he couldn't say the words.
Okay,
You know.
so he really was in love with his daughter.
In love with his daughter, completely in love with her.
Oh,
Yeah.
that's sweet. That is sweet.
Yeah.
Because he was trying to do the right thing.
Trying to do the right thing.
Did they go as far as to ask whether he paid child support or not, or did it get that deep?
Oh, no, it didn't get that deep.
Because he was living there with her, so they were
Right.
kind of like common law
Right.
on some. Because her mother was in Iraq, so he was there in the house with her, with his baby's mama, with the
Right.
girlfriend.
Right.
Okay, well that's good, and the girlfriend testified, so it corroborated the story, which was helpful.
That was helpful.
Okay, that's good. That's good. That's good. So let me make sure I understand. We have 3 minutes to wrap this up. Ultimately, showing he didn't live there. So does the jury just believe that he was really on the couch sleep, and he just wasn't aware that cocaine was in the bedroom or in the kitchen, and the marijuana was in the bedroom? How did they feel beyond a reasonable doubt that he still wasn't in possession of it,
Well, they
or wasn't aware of it, or didn't know about it?
they felt that the state was not able to prove that he was aware of it.
Because he'd only gotten there at like 3 in the morning. This is 10 in the morning. He had been asleep. So whatever was going on in the bedroom and in the kitchen, he might not have even been aware of.
Not have been aware of. And so one of the questions the prosecutor asked was, "What about the lease?" And one of the persons in the jurors said, "Well, I could have something that's old and somebody's going to have possession of it. Doesn't mean that I live there,
Right.
because could be many reasons why."
But did
it's
they
there.
have the lease?
Did
Did the DAs produce the lease?
They did not. Did they? They didn't. I don't recall them introducing the lease.
Because the significance of the lease is that the lease is not for that address. So,
Right.
I mean, it just means that it was in his property, but it was actually in his cousin's property, right? That he moved over there.
Brother-in-law.
Brother-in-law's
Right.
property. Okay.
Right.
Right.
But it doesn't mean you live there just because a piece of document has your name on it.
Right, but that was their position, because this lease, even though it wasn't to that property, had his name on it. How would it get there if he just walked over there?
That's correct.
And so their issue was a lot of the property there was his brother-in-law's property, and he had leased the property for the brother-in-law that just
Right.
happened to have his name. So
Right.
he had a nexus to the house, but it just didn't mean that
He lived
he
there.
lived there or was there on a frequent
Or
basis.
had any control over what's in the house.
Right, control over what's in the house. Well, we have 1 minute. My director is telling me to wrap this up. So what's your closing statement?
Let's see. What would I say would be my closing statement? What did I learn from this trial? What did I learn?
Well, while you're thinking, I would think that we learned that never give up. If your client says they're innocent, even though it appears that they're guilty as hell, and you investigate the case, maybe they are innocent. Because I believe it seemed, the way this report was written, you would think he was guilty. When I read it today, I'm like, he seemed guilty to me, Cheryl. But once you do the investigation and you listen to your client's side of the story and you investigate it, you believe that he's not guilty. And you were able, with your experience, to bring his side of the story alive, his witnesses alive, to show that he was not guilty. And a jury of 12, who most of which probably didn't look like him, still thought that he was not guilty. So that was a glorious day in the Harris County Courthouse. I'm getting the wrap up. If you want to say something quickly, go ahead.
This is one of those days where you have to play your cards close to your vest, and that's what I did.
Thank you so much, Ms. Cheryl Irvin, famed Houston defense lawyer. Thank you for sharing your story. Thank you for being my friend. Thank you for always being there to bounce other stories off when we represent our clients, because it is a tough fight down at the Harris County Courthouse. Thank you for watching Truth and Justice with Vivian King. Please watch next week when we have another educational story for you. Good night. Thank you for tuning in again tonight. We have something really good, a hot topic.